Vladimir Zukoski. The state is seeking to elicit from Trooper Newcomb testimony to the effect that traumatic events such as motor vehicle crashes may mask signs of impairment and make it more difficult to observe signs of impairment in an individual, impairment either by drugs or alcohol, than would otherwise be the case. The defense objects to that testimony, arguing that it has not opened the door to the admission of that testimony, and that the trooper's testimony is expert testimony, not lay testimony. The state contends that, relying on State v. Bolton, that the testimony that it seeks to elicit is lay testimony, not expert testimony, and therefore may be brought out on redirect examination. I have reread State v. Bolton, 174, New Hampshire, 470, and the other case to which the state alluded, which the Bolton court also compared and contrasted, State v. Gonzalez, 150, New Hampshire, 7 at 74. Having reviewed, and again, we did undertake Trooper Newcomb was examined outside the presence of the jury regarding the basis of his, the specifics of what his testimony would be, and his bases for expressing those opinions, which the state argues as lay opinions. Again, one of the state's argument is that that the Bolton court emphasized that the information was being elicited on redirect examination, not in the state's case in chief. That is correct. In Bolton, however, the defense counsel, as part of defense counsel strategy, had asked the officer, and another basic proper procedure is to try to do interviews in closest time as possible to an event, right? And this is in a sexual assault case, and they were discussing the Child Advocacy Center interview of the alleged victim. The officer, the witness, disagreed, explaining that the timing of interviews varies by case and that sometimes it's beneficial actually to wait for a person to process that information before we speak to them. And then the New Hampshire Supreme Court noted that on redirect, the state simply provided the officer an opportunity to further explain that answer, and then she gave the response at issue, which the defendant in that case objected and argued was inadmissible expert testimony. With respect to that issue, unlike in Bolton, defense counsel did not elicit. Defense counsel clearly questioned Trooper Newcomb regarding or elicited substantial evidence to the effect that he did not observe signs of impairment in the 4 or so hours in which he spent with the defendant at the Jefferson Fire Department, the hospital, the police, the hospital, and the motel where he helped him to check in. But defense counsel did not elicit the testimony that the state now seeks to admit and now wants, that the state now seeks to admit. That is, the defense counsel did not on cross-examine elicit any reference to this theory or opinion that the state now simply wants the witness to amplify or complete his answer. So the case I find is distinguishable from Bolton in that context. With respect to whether it's lay or expert testimony, again, in Bolton, the New Hampshire Supreme Court concluded that it had little trouble concluding that the average juror is familiar with the notion that a person might be better able to remember and discuss traumatic offense after some time has passed since the events occurred. Again, the court recognized that just about everybody everybody has experienced one or more traumatic events at some time in their life, and have had the experience of having to process that event and then be able to relate that event or discuss that event with others. That I find is different in nature and kind from the evidence the state seeks to elicit. That is, although jurors may be generally familiar with the notion that a traumatic event may be traumatic and they may have experienced that trauma, they are not familiar with the notion or the state's purported notion that the traumatic event masks signs of impairment by drugs or alcohol and makes it more difficult to determine for the investigating officer in this case to observe signs of impairment. That as Attorney Merkin notes, it's to some extent chemical. This is scientific testimony, not lay testimony with which jurors would be familiar. And again, there may be some witness out there, I don't know who's on the witness list, who is qualified to testify about this. But Trooper Newcomb is not it. Again, it's being offered as lay testimony, and, you know, it's simply expert testimony. Again, because it's it's expert testimony. Even if it was, it would need to be reliable. And I mean, Trooper Newcomb's testimony is that when I asked whether the traumatic event would have any effect on, you know, some of the symptoms that heroin or fentanyl would cause, like the pinpoint or constricted pupils, his answer was he wouldn't think so. Whether it would have effect on droopy eyelids, he didn't know. But in any event, this is not the type of lay testimony that any juror would understand because they've experienced it. Every juror may, as in Bolton, have experienced a trauma and understand that it takes time to process, some distance from the trauma and time from the trauma to process the trauma. That is not true of the notion, the proposition that traumatic events mask signs of impairment and make it more difficult for an investigating officer in this case to observe signs of impairment. So for those reasons, I'm going to sustain the defense's objection to that line of questioning and exclude it. Anything else at this point?
No.
Recess?
Thank you.
All right.